Hello, my name is Gay Truscott, and I'm a financial advisor and certified financial planner with Edgemoor Investment Advisors. I have spoken at past forums on a number of financial planning topics, including retirement planning, Social Security strategies, and my favorite topic, women and wealth. For this talk, I'd like to broach a topic that is difficult for some families to discuss. That is, how to plan for your family's inheritance. I understand, talking about and planning for your own mortality is not easy. But it's extremely important for each of us to think about our wishes, articulate them to our heirs, and make sure our financial affairs are in order to ensure an orderly transfer of our wealth and wishes to our beneficiaries. So let's start with some background on what is often referred to as the Great Wealth Transfer. An estimated $85 trillion of wealth, and that's trillion with a T, is expected to be transferred to younger generations over the next 25 years. And this will primarily come from baby boomers. There are an estimated 68 million baby boomers spanning an age from 60 to 78, and they hold roughly 1/5 of the world's total wealth. This is an extraordinary amount of wealth that will be passed on to the next generation, so it's important to plan for it. Here are 6 important steps that will help you plan for your family's inheritance. Number 1, make sure your financial affairs are in order. Start by creating an inventory of all your assets, including your bank accounts, brokerage accounts, retirement accounts like 401ks and IRAs, insurance policies, real estate, and personal property. In addition, you should make a list of your online passwords and keep it secure, of course, as well as a list of your professional advisors, your financial advisor, legal, tax, and insurance advisors, so your heirs know how to access your accounts and whom to contact when it becomes necessary. Number 2, update your estate documents. We typically advise our clients to update their estate documents at least every 5 years, or sooner if your life circumstances change or if tax laws change. And the basic estate documents should include your will, trusts, powers of attorney, and a medical directive. These basic estate documents are essential to ensuring a clear, orderly administration of your estate. Number 3, understand the legal consequences of your estate plan. And what do I mean by this? Well, different assets have different rules about how they can be transferred. For instance, retirement accounts, as well as most life insurance policies, pass directly to the named beneficiaries on those accounts and are not governed by your will. So that means you have to make sure those beneficiary designations are up to date and correct. And now, an example I will share with you of what can happen if they're not. Imagine your life insurance policy passing to an ex-spouse long after a divorce if the beneficiary designation was not updated to a new spouse or another heir. This has happened. We've seen it. And there's essentially nothing you can do after the fact to prevent it. So make sure your beneficiary designations are up to date. Number 4, stay flexible. Things can and will change over time, like unexpected medical costs, a divorce, or tax law changes. So this is why you need to stay flexible and revisit your plan frequently. Number 5, communicate often. Communicating in advance of a loss or some other life-changing event is a good way to ensure everyone in your family is on the same page and knows what to expect. And this includes communicating not only about your physical assets, but also the values and principles that you want your heirs to carry on, like spending prudently, saving and investing for the long term, or giving charitably. These are all parts of your legacy which are important for your heirs to know and understand. And finally, seek help and advice from a financial professional. This is what we do at Edgemoor: provide comprehensive financial planning advice to our investment management clients, including helping you set your goals and needs, crafting an investment plan to meet those, and then working with you, your family, and your other professional advisors to carry out your wishes in a comprehensive manner. Now I'd like to move to a case study on how to plan for an inheritance. Remember that $85 trillion of wealth that is going to transfer to the next generation over the next 25 years? Well, a large portion of that is in the form of real estate. And unlike more liquid assets like stocks and bonds, real estate can pose some unique challenges when planning to pass it on to heirs. So let's look at a specific situation that has impacted many families, including mine, and that is passing down a family home to the next generation. Here are some important questions to ask. Who actually wants the home, and who will use it? Can all the beneficiaries afford it? What is the best form of ownership for the property, and how will it be managed or maintained? Will this property make up the bulk of the inheritance your heirs will receive? And how do you compensate family members who can't or don't want to participate in joint ownership of a property, particularly if equal division of family wealth is your goal? Other factors to consider, and I call these soft factors. Generational homes can carry strong sentimental value, which can lead to emotions outweighing practical realities, like financial realities, which often does not lead to good outcomes. Some heirs or their spouses may have other family obligations or traditions that would limit their use of the property. The property may be geographically challenging for some heirs. For example, a sibling who lives on the West Coast may not get maximum use out of a summer home in, say, Maine. And the beneficiaries, no matter how close, may not work well together as co-owners of a property. These are things to consider carefully when deciding whether and how to pass down a family home to the next generation. Now, assuming all parties involved do want to do this, you need to consider what form of joint ownership makes the most sense for you and your family, and whether you transfer that ownership by gifts during life or as a bequest after death. Let's look at some different types of ownership. First, outright shared ownership. Very simple, typically structured as joint tenants or tenants in common, depending on your state. Second, ownership through a trust. This may be the most common form of ownership and simply requires that you retitle the property in the name of the trust and then name your heirs as the beneficiaries. You must also name a trustee of that trust, who could be a relative, a friend, or other independent entity. The trustee selection is very important, as that person or entity will be in charge of making decisions about the property, including about finances, usage, and buy-sell procedures. So choose your trustee carefully. The next and perhaps least known option is ownership through an LLC, or limited liability company. Much like a trust, this requires that you transfer ownership of the property to the LLC and then distribute ownership interests or shares to your beneficiaries. And this is often done gradually over time using the annual gift tax exclusion, which is currently $18,000 per person per year or $36,000 for a couple. So why use an LLC instead of a trust? Here are some of the advantages. Control. Parents continue to use and control the property and make important property decisions if they are greater than 51% shareholders of the LLC. Flexibility. LLCs are very flexible, and the transfer of ownership interests is very easy because it's essentially a transfer of personal property versus real property. And because it doesn't involve real property, the transfers don't impact mortgages or trigger taxes or title changes. So this can save considerable time and money. And finally, asset protection. Properties in an LLC are shielded from creditors and from ex-spouses. So they provide limited liability to their members. For any of these ownership structures, here are a few other tips to consider. Pre-funding an operating account for the property to cover, let's say, 3 to 5 years worth of taxes, maintenance, and insurance costs. This would help buy some time for your heirs to get used to co-owning a property. And you could use either current funds from your estate or designate life insurance proceeds to fund the operating account. And create a written master operating agreement to spell out important details like financial obligations, funding arrangements, usage agreements, rental periods, and buyout procedures for the property. The more you spell out these details ahead of time, the smoother the transition to joint property ownership will be for your heirs. That concludes my planning remarks. I hope you found this interesting and informative. We are here to assist our clients at Edgemoor with these and other planning issues, so please don't hesitate to reach out to us. I always like to end with a little financial planning humor. So here goes. Obviously, you want to avoid this situation where two heirs are fighting over a home and literally splitting it in two. Thank you for listening.